factual and timely.
And welcome back. Thank you so much for staying with Lookup TV. We've now changed the set because it's time for our discussion. And remember, what's on the inside tonight is leadership and integrity, which is Chapter 6 of the Constitution. And joining me on set is Annette Kwamboka, who's an advocate of the High Court. Welcome.
Thank you so much, Nelima. So good to be here as always.
Yeah, it's always a pleasure. And let's just jump straight in.
Yes.
And we know that there are many cases before the IBC Dispute Tribunal.
Yes.
And ranging from former Nairobi Governor Mike Sonko.
Yes.
And the case that is now ongoing, which is Nairobi Senator Johnson Sakaja.
Yes.
And of course, these are cases that border leadership and integrity.
Yes.
So I know we are not supposed to talk about cases that are in court by law.
Yes, yes, it's a concept called sub judice.
Right.
Yes.
But for the purposes of our discussion, so we know that Senator Sakaja's papers, his degree is in question.
Yes.
Yeah, and if we go back in history, then he has been a serving senator in
Yes.
in Nairobi County, and so where would you say did the law fail,
Yes.
or the implementers?
Yes.
Because if the degree is in question right now,
Yes.
then so whose fault is it?
So, in my opinion, this just casts an aspersion on the process of vetting that happened before, you know, because he's held public office. And the question is, why is this coming up right now? I do remember in 2017, there was a bit of furor about his academic qualifications, but that never got to the sort of judicial place it has gotten to right now. Of course, there's so many determining factors, and him on the other end would say, of course, these are perhaps my political opponents, or this is just part of a very deliberate strategy to either affect my campaign or my ability to attain the specific office that I'm going for. But the truth is, where we are right now, a complaint has been lodged to the IEBC Dispute Tribunal for a decision to be made, and we wait to see what can be done. I cannot comment to the process that was there before.
Right.
What we know right now, and with the information that we do have right now, and that we can validate that is factual, is that a complaint has been lodged, and there is a reason, or rather, the Disputes Tribunal will have to determine the probity of his academic qualifications and whether then he is suitable to run for the office that he is running for, and we wait to see how that will go.
Right, and there's this aspect of technicality.
Yes.
That sometimes some cases say could be the degree one.
Yes.
And on a matter of technicality, there are already some three. Some of he had 5 charges.
Yes.
And 3 have already been thrown out.
Yes.
Because the petitioners did not show up in court. Mm-hmm. So that technicality right there, is this why they say the law is on us?
Well, the provisions of the Constitution when it comes to access to justice, and also under the Civil Procedure Act, we have what we call the overriding principles, which matters, technical matters, should not be used as an impediment to arriving at a just decision, right, or at a just arrival at a decision of a matter. I think it's very circumstantial to look at. It doesn't necessarily mean that technicality itself, or a simple basically what the law provides, that a simple technicality, right, should not stand in the way between a matter and the just arrival of a decision regarding that specific matter. I would address myself to the issue of the petitioners not appearing before court. It will then perhaps also be tied in with them being able to then produce enough information as to what they are claiming on those 3 particular grounds, I would say. But without going into too much into it, because it's still a matter that's yet to be decided, right, we will need to see, and of course find the final determination, read and determine what the IEBC Commission has found in the case.
Right.
Yes.
And when we look at now the Constitution,
yes,
Chapter 6, which is the leadership and integrity focus tonight. And authority assigned to a state officer.
Yes.
It is a public trust to be exercised in a manner that is consistent with the purposes and objects of the Constitution, demonstrates respect for the people, brings honor to the nation and dignity to the office.
Yes.
And we have seen the Office of the Director of Public Prosecutions, as well as the Ethics and Anti-Corruption Commission,
yes,
that they have mentioned their names that have been submitted even to the IEBC.
Yes.
That these candidates have cases in court, their integrity is in question, therefore they cannot vie. And we saw the IEBC respond saying that until people are proven guilty, then they're free to run for office.
Yes, and that is the purpose of that specific tribunal.
Right.
I would like to refer to the provisions of the Constitution under Chapter 6, which has the principles of leadership and integrity under the Constitution,
right,
as then now enabled and brought to life under the Leadership and Integrity Act, which then sets up the Ethics and Anti-Corruption Commission. Then we also have the Public Officers Ethics Act. And this framework in itself sets out a code of conduct for people seeking to hold public office or for people who have held public office. You see, there's a procedure under the Leadership and Integrity Act where a public officer is deemed, or there is cause to then imply, or there is reason to believe that this public officer has acted in a way that contravenes their responsibilities under Chapter 6 of the Constitution.
Right.
And as a public officer, then that public entity has to investigate that particular complaint. And after it has investigated and it has found probity or weight when it comes to those allegations, it will refer it to the Commission, Ethics and Anti-Corruption Commission, and the Attorney General if it's a civil matter. And then if it's a criminal matter, it's referred to the DPP, who can then instigate criminal proceedings against this public officer. But you know, substantive conclusion on whether a person is guilty is where we have determination by a court or by an entity that has jurisdiction to listen to that matter. So yes, what Mr. Chebukati said was right. A decision has to be made. And how we know substantively that a person is guilty of something is where we have a decision, either in a civil case or in a criminal case. But sometimes the commissioners, the IEBC commissioners, because remember, for example, for the seat of a senator, one of the grounds is that you must not have been found to have been guilty of acting in a way that contravenes the code of conduct of a public officer.
Right.
It could be on the facts or the grounds, or rather the strength of making a decision would be, for example, if there's a decided case against a person. But remember, there are so many matters that are brought to the Ethics and Anti-Corruption Commission that have not yet been decided yet. But there's still enough evidence. The commissioners can go off that and make a decision as to the probity and as to the suitability of a person, right, to hold a public office.
For a commission like the EACC,
yes,
then they are like the watchdogs of corruption.
Yes.
And so the question would be, if there are aspirants, potential the candidates for different elective seats,
yes, and
their integrity is in question, they probably
yes,
have cases in court,
yes,
like the likes of Sonko, Wavinya Ndeti,
yes,
Mithika Linturi. You know, there is a lot of questions about either the academic papers as well as corruption cases.
Yes.
And of course, then if they get into office and then the cases, the ruling, the verdict says that they are guilty, then yes, what happens then?
Well, then if they are guilty, then they will be bad. Because remember, under the Elections Act, the IEBC, the dispute resolution, that tribunal on disputes is required to arrive at a decision 7 days after a complaint has been lodged when it comes to an electoral dispute of a nomination nature.
Right.
So in such a situation then where a decision has been made, the person who is now found not fit to run for office then cannot run on the strength of that decision. And then the party will then have to find another contender or a running mate for that position.
Okay, and so when this candidate runs for office,
yes,
then they make it in, say, be a governor or a senator.
Yes.
And then now that's when the case, we get now the verdict that they are guilty. So what happens at that time?
So there are two stages under the Elections Act. The first one is at the nomination stage. If at the nomination stage there is reason to believe that this person is not suitable to hold office, then a complaint will be lodged by a party, an interested party, whatever the case may be. Then that the IEBC Dispute Commission, the Dispute Tribunal rather, will have to make a decision within 7 days, and that's why we are seeing they're trying to rush to make a decision. As you saw, parties could only give submissions for up to 5 minutes. It was very quick because only have 7 days to make a decision. Then if they're found fit to continue running, if the tribunal determines that there's not enough or sufficient evidence to find them not suitable to run for this office, they will run. And in the event that they win, a person or a contender, now for example it could be a competitor running for the same seat, finds that the electoral process was not done in a proper way or in a just way, they will then now institute an election petition in respect to that specific election of that candidate. So it's at two stages. It's at nomination stage, and at that stage it's the IEBC tribunal that has jurisdiction. Then if a contender proceeds to vie, is cleared to vies and wins, but a person feels that the election process in itself was significantly flawed, they file an election petition, and the High Court has original jurisdiction to listen to that matter.
Okay.
Yes.
What the CJ Martha Koome has been trying to solve the backlog of cases.
Yes.
And we know that there are some candidates who are running for office,
yes,
but they have so many cases in court.
Yes.
And so the duration, how long does a case take in court, say for corruption allegations?
It's completely circumstantial. You know, I really cannot say that it takes 1 year, that it takes 2 years. But the truth is, one of the overriding principles that I mentioned earlier is that there has to be the just and expeditious determination of matters. So a matter should not be prolonged unnecessarily without reason. What I will say is, when you look at section 74 of the Elections Act, it provides that a decision, for example, when it comes to the dispute of a nomination, it has to be determined before the election date or before the nomination date, whichever applies. So over here you will find like Senator Sakaja has already been nominated. So what we're looking for is that a determination has to be made before the date of the election. So when it comes to the duration, I cannot say, but at least looking at section 74, and as it then applies to the IEBC tribunal, a decision has to be made before the elections.
Right.
Yes.
And we've seen a lot of different politicians saying that some of these accusations,
yes,
and the charges that have been made against different candidates that are just political. It is, yes, a political witch hunt.
Yes.
So what are your thoughts on this? Because there's an impression that it gives that we're now politicizing, we're now making these matters political,
yes,
matters of corruption. You're politicizing corruption.
Yes.
But so do you think that in any way affects the case?
Well, as an advocate, I cannot address myself to speculation. Remember, when a person says that, oh, it's my political opponents who have orchestrated a strategic witch hunt against me, it's difficult. How do you then prove that in a court of law? Remember, when you're taken before the tribunal, it's for very specified issues that have been provided under the court of law that a person has then breached,
right,
or that you don't meet specific set out qualifications under the constitution or under any other law.
Right.
So, Nelima, what I would say is that if I was to speak outside of being an advocate, as an advocate, I cannot address myself to speculation. But what I would say as a citizen, it's purely circumstantial. The truth is, if there is reason to believe that you are not suitable, let it be taken to the requisite tribunal, which is the IBC tribunal in this case. Let it be decided in the case of an election petition. Let the court decide. But a political witch hunt is not one of the grounds, right, for disqualification under the law. Well, I wouldn't be naive to not say that it's a factor. It may be a factor, but as a person, as an advocate, as an officer of the court, I have a responsibility to defend the law, and I will only address myself to such issues within the parameters provided for me by the law.
Right, and
yes,
there is the court of public opinion,
yes,
which is the people.
Yes.
And there have been some cases where critics have argued that the court gets pressure from the public. You know, like, now this case needs to come to an end because there needs to be a villain, someone charged for this, for people to feel vindicated.
Yes. So under the constitution of the provision,
right.
Under the provisions of the constitution, rather, sorry, we have provisions on access to justice. And some of the principles under that provision in the constitution is fairness and impartiality. The judiciary itself has to demonstrate that it is impartial. Of course, we know that with social media and with the changing way with which people receive news and make
right.
news, there are a lot of opinions flying around. But when we have judicial officers, they go through a process of vetting. By the time a judicial officer is appointed to the magistrate court, high court, court of appeal, Supreme Court, they must demonstrate that they're suitable to hold that office and be able to hold up the principles of access to justice, which is fairness and impartiality. And I dare say that we should be able to put enough faith in our judicial system. It may be compromised. I cannot be naive about it. But our judicial system should be independent, because it's independent when it comes to the three arms of government. It's an independent arm of government.
Right.
And the Constitution has given it that responsibility to ensure that justice is dispensed, and they're the ones who interpret the law. So I would expect then that the judiciary should essentially be impartial, it should be fair, it should apply itself to facts, it should apply itself to the law as it then applies to those facts, and make a decision notwithstanding what the public opinion is. That is what we call fairness.
Right.
Yes.
And now that informs my next question.
Yes.
Is the judiciary really independent? Because there have been times that they have been accused of being a state agent, and of course going for someone who is against, say, the president.
That's a very it's a very heavy question to answer, also as an officer of the court, as I am, as an advocate.
Right.
What I will say is that I cannot address myself specifically to whether the judiciary is impartial or whether it's not, without then having the burden to go and look for statistics, to go and have to look for reports,
and give evidence.
And give evidence,
right.
and read up and demonstrate then that the judiciary is not impartial. I can just not make I cannot make a blanket statement over here and say that the judiciary is not impartial. I have to go and get the supporting information and evidence to say that. But what I will do as a lawyer, I will go back to the law, which is my comfort. And there's a concept of separation of powers, which has been manifested in our constitution.
Right.
So we have the judiciary, we have the executive, and we have the legislature that play their independent roles. And if we then abide with the principles of the constitution and the principle of separation of powers, the judiciary essentially should be independent, it should be uncompromised, and in that way it should be able to interpret the law that emanates mostly from the legislature, sometimes from the executive, in a way that is impartial, in a way that is fair, in a way that is expeditious, and in a way that the rule of law is upheld at all times. Yes.
Right. And the National Integrity Alliance, it gave a list of several names, 25 political aspirants in question.
Yes.
So when such independent bodies then file complaints to the IEBC,
yes,
I know you have stated that, of course, the IEBC's stand, they will not block any candidate from vying unless they're declared guilty. But so then what happens to these 25 people that are in question, as well as the 241 that were blacklisted by the movement, the red card movement?
Well,
you know, there is an impression that the public now has,
yes,
on the same, but now the law is the law.
And exactly, the law is the law. So all these people whose names have been submitted will have to go through the same process, and that process is steeped and it's set out in the law. First of all, whether they are suitable to hold the office, that is, they meet the qualifications, and number 2 or number 3, or it depends, whatever the circumstance is, have they violated any code of conduct, especially if they've held public office before. Has it been decided or has it been determined by a court of law that they have violated their responsibilities as public officers under the Constitution, under the Leadership and Integrity Act, and under the Public Officers Ethics Act. So the truth is, I can come up with all these names. I can say, Nelima, you are not suitable to run for governor of Nairobi County, and I take your name to the commission. But irrespective of the emotive aspect of me giving your name, it is said that you stole money here. It is said that you acquired property fraudulently here. The law has to apply itself to the facts, compare it to the law, and determine, has a provision of the law been breached? Has a decision been made, a binding decision, that then we can apply ourselves to, or that we are bound to see then? So that procedure has to be done. So the truth is, and that's where fairness comes in. I can claim, I can provide the evidence, let an impartial body make the decision, and then after that, it will be determined whether I am ready, or rather I am suitable to hold that office or run for that office.
Right.
Yes.
And even as we close, then what should the common mwananchi understand? Because when a candidate has been accused of corruption,
yes,
you know, there's so much that goes on. Either it is a political witch hunt, or these are just plans maybe by their own party to frustrate them.
Yes.
And then when it's taken to court, so either they expect the process to be fast, or the other thing that people say out in the streets is that this will probably not go anywhere, because we've never seen a verdict of any high-profile person on a corruption case. Maybe take us through the process so people really understand what makes it so lengthy. And are we ever going to get to a place where we say, now at least we got a verdict from this case of a very high-profile person who's been accused of gross misconduct, abuse of office, or serious corruption allegations?
I would say that in the past 10 years, we are seeing more, and we are seeing, especially, I would say, offices like the Director of Public Prosecutions becoming very bold in pursuing persons who are thought to have either misappropriated their powers in their office in a way that then would be construed to be a criminal offense. And also the Ethics and Anti-Corruption Commission over the past 10 years in pursuing persons who have really been heavy-handed or misappropriated their powers contrary to the provisions of the law and the Constitution. What I would say is that it's true that indeed, and not just in Kenya, in Africa, where systems are weak, people will always take advantage of those systems. People who have power by virtue of political office, financial power, that ability to be able to manipulate or intervene into an outcome to skew it towards your own benefit. It's possible. It has happened so many times.
Right.
I would not want to address myself to any single particular case at this moment, and I would understand that sometimes the sort of worries and fears that the electorate have in terms of justice being done and being seen to be done and the whole process, the worries are very, very valid. But my hope will be that in the coming years we can have more transparency, we can have prosecution of cases to the very end, and in a way that is expeditious, taking into account the nature of the case. And you've asked me to go through the process.
Right.
So, for example, I am a holder of a public office. I am employed, for example, in a ministry, and it is thought, or there is reason to believe, that I have pilfered the coffers of that ministry. I have transferred money to my account. my husband's account, my children's account, as the case may be, or to a foreign account, and things like that. So what will happen under the Leadership and Integrity Act, that public entity is required to undertake an investigation into that matter and determine, is it true that this officer in our entity has carried themselves in such and such a manner. Then after the entity has carried out its investigations and has reasons then to believe that there was misappropriation of powers by this public officer, they will either do it in two ways. They can refer the matter to the AG or the Ethics and Anti-Corruption matter, where it's a civil matter. Right. Then when it's a criminal matter, that matter will be referred to the Director of Public Prosecutions to pursue criminal proceedings. So the Ethics and Anti-Corruption Commission and the AG will pursue civil proceedings, and the Director of Public Prosecutions will pursue criminal proceedings, which then all have the individual procedures. The burden of proof in civil proceedings is for criminal proceedings, it's beyond reasonable doubt. Right. And then on civil proceedings, it's a balance of probabilities until a decision is then arrived at. Now, the procedure under civil proceeding or under criminal proceeding then can be prolonged for a very long time. And we know that it's in these procedures in the court that sometimes they're prolonged for purposes of either deterring prosecution, to make the public lose interest, and to bring in that prosecution lethargy, so that then the case just disappears or it fizzles out, right, or it's then dismissed for want of prosecution. And that is why things take long. But I do hope that even when we elect our leaders, we will want to elect people who have our interests at heart, who will elect persons to these offices, the AG, the office of the AG, the office of the DPP, appoint such persons who can carry out their responsibilities independently and as required under the Constitution, so that then the principles of access to justice are upheld, the rule of law are upheld, separation of powers are upheld, and so that independent offices in the government or independent offices in the country are able to carry out their mandate properly, right, and without any intervention that would be onerous. Okay,
but before we close, yes, the issue of funding has affected the judiciary and the different even institutions like the EACC, yes, that are there to fight corruption. Yes. So what are your thoughts on the same, and to what extent do you think it affects their responsibility to be gatekeepers?
So, you know, we have the public exchequer and we have the consolidated fund, where money that runs the government, essentially, where money that runs the state is kept. Right. And every office, every entity, every independent arm of the government has its budget. The Judiciary has its budget. The Ethics and Anti-Corruption Commission has its budget that's usually tabled before Parliament, approved by Parliament, and then commissioned for withdrawal for the consolidated fund to these entities. Right. And the truth is, we've never had a position where the Judiciary is saying, yes, we are satisfied that we have enough resources, you know, to be able to carry out our mandate. I mean, the thing is, it's neither here nor there. What I would say is, what we need is proper management of public funds. Right. And Nelima, when you go back to the Constitution, we have provisions on public finance management. On top of that, we have the Public Finance Management Act. And if we abide by these principles and manage the state's money in a fair way, in a shrewd way, and be able to allocate to very crucial entities like the Judiciary the funds that they need to exercise their mandate, we will probably see some of the problems that we're experiencing in the Judiciary, short staffing, matters taking long to be determined because right, a judge has so many cases, you see, and things like that. It will help the Judiciary exercise its mandate better. So you are right. We really need people, and we need leaders who can manage our finances well, who can allocate our finances well, right, so that then the mandates of various public entities are exercised well, and the person who then benefits is the citizen.
Thank you so much. Yes. And that is Annette Komboka, Advocate of the High Court. Thank you so much for your time. We have been talking about Chapter 6 of the Constitution, and of course there are a lot of cases before the IEBC Disputes Tribunal over the question of integrity of candidates who are running for different elective seats come the August 9th elections. And of course, we'll be looking more into what the Constitution says in the coming weeks and just getting an in-depth of how you can be able to understand your rights and of course the provisions that are in the Constitution regarding different matters, from land ownership to your rights as a person, freedom of speech, freedom of the media, and so much more. So do keep it Look Up TV, and of course the hashtag Insight. Thank you so much for watching. Do have yourselves a pleasant evening. Good night.
Factual and timely.